Senator Case,
Present.
Senator Dockstader,
Here.
Senator Ide,
Here.
Senator Pappas,
Not excused. Excused.
Chairman McEwen.
Here.
Mr. Chairman, you have a quorum.
Okay. First bill for our consideration is House Bill 130, Second Amendment Protection Act. And sponsor would like to come up first.
Thank you, Mr. Chairman. I apologize for being late. You guys got out a little earlier than we did. I had to sit there for some third reading. But I'm here now, so I appreciate you waiting and give me a chance to get down here.
Does Saturday look okay for you this weekend?
Yeah. I think it's still free. Hasn't been committed yet. Anyway, what I have before you today is it's a old friend that seems to keep resurfacing, but it's the SAPA bill. It's the Second Amendment Protection Act. This basically does two things. It brings in a civil proponent or a civil component to the SAPA bill we passed a few years ago. And what it does is it addresses two issues. If a federal order is given that would violate our constitutional rights, what this bill would do is it would protect not only us, but the law enforcement officers that may be given an order to go enforce a gun seizure, for example. So this bill would stop any of the law enforcement entities in the state of Wyoming to enforce laws that are outside the state of Wyoming. We recognize that we can't tell the federal government what to do, but what we can do is we can have the directive given to our law enforcement entities that they are not to violate our Second Amendment rights should an order ever be issued. And the second part of this is it also addresses, a lot of times they'll have an MOU where some of our local officers will be augmenting some of the federal actions, like with ICE, DEA. Quite often they'll task some of our law enforcement officers in the state to assist them. And there's been a lot of confusion, but this bill really, all it does is it says if the primary action is going to be to address Second Amendment rights dealing with firearms, munition, or accessories, that they cannot do that. There's been a lot of confusion as far as what they can and can't do, but it does not prohibit. I've seen some messages go out where it said that we can have our officers assisting with ICE, and that's not true. They can assist. What they can assist with would be if an order came down that the ATF was, for example, going to come in here and seize AR-15s or 30-round magazines. This basically just says that our guys cannot do that under the umbrella of their office that they hold, or that they can't be basically leased out or rented out to the federal agency that's coming to do that. So I hope that's a good enough explanation. This really is the Senate File 196 that we passed last year. We just brought it back, and there has been a few cleanup things. I think there's been a couple good amendments. And with that, Mr. Chairman, I'll stand for questions.
Questions? I think we'll, did you bring any of these amendments?
There have been amendments that we've brought. There is an amendment that we were hoping to get introduced today. The intent was to have House Bill 130 mirror Senate File 0101. And we've had amendments. The amendments were the same, but the way the verbiage was kind of the House had its order and the Senate had its order. So we've supported all the amendments that have been brought forward. I think they've been good amendments. We've tried to work where we can with our local law enforcement people. We've tried to adopt the ones that we felt added to it and kind of address the concerns that they had brought. But with that, that's the only thing. I do have a proposed, I don't know if you want to have it as a standing committee amendment, but I don't know, do you have the copy of that?
Just curious. We'll get to that later.
Okay, I just have copies if you guys needed to have it, but that's what we would like to do, is have Senate File 101 mirror that of House Bill 130. So.
Any other questions? Senator Ide.
Thank you, Mr. Chairman. Representative Wharf, thanks for being here. Can you talk about the federal funding aspect of this bill? That's my question. Thank you.
Yeah, thank you, Mr. Chairman and Senator Ide. Yeah, I mean, I know there's been some concern that they won't be able to take the money, and I don't know what all the MOUs are that exist between, our law enforcement entities and those of the federal government. They could better address that. But as far as this goes, the way I understand this bill is, the only thing that our guys can't do is they cannot go seize firearms, they can't seize munitions, and they can't seize the accessories. And that's all it says. It doesn't say that the federal government can't come in and do that. It just says that we can't assist. So there's been examples, like I heard if there was an armed robbery in Colorado and for whatever reason the assailant jumped in a car and came up to Wyoming thinking they'd be safe here because our guys can't do anything. That's not true, because the primary purpose in stopping that individual is the fact that they robbed a bank. The fact that they had a firearm was an accessory to that offense. So it wouldn't prohibit our guys from helping, because the primary purpose of catching that individual is not because they had a firearm, it's because they robbed a bank with a firearm. And so that's been some of the things that I've heard in the chamber, in the halls, people have been talking about it, and it clearly does not prohibit them. I know one county said that if this were to pass, they'd have to tear up their MOU to assist ICE. And I don't see how that comes into this. ICE is dealing with illegal immigrants. Number one, this bill is only for citizens, and it pertains to Wyoming law. So somebody that's here illegally is an immigrant. This doesn't give them any protections. If they're in possession of a firearm, they're already here illegally. That's the primary focus. The firearm would just be in addition to that offense. So it does not prohibit our guys from being able to do something unless they've agreed to enforce all federal laws. And I don't know how they write them, but hopefully if this passes, we can, if they have an MOU that doesn't do that, it would be an amendment to the MOUs that they have with the federal agencies, that they can't participate in any direct effort to seize firearms, munitions, or accessories. But I didn't give you a dollar amount, but I hope that answers your question.
That's good. Thank you.
Quick question. If they're working with one of the federal agencies and part of the task during that requires them to seize firearms, are they still okay? I understand day to day, they come across somebody robbing a bank in Wyoming or wherever, they can take the weapons.
Yeah.
So let's say they're working with DEA and the situation arises where they need to take weapons. Are they okay to do that?
Mr. Chairman, my understanding is that they are, because the primary purpose of the interaction between the law enforcement entity had to deal with drug enforcement actions. It was not a direct order to issue seizure of that firearm. But obviously, we want our officers to be protected. I know in most instances, if I'm carrying a gun and I'm interacting with the law enforcement officer, if they ask me to hand them my firearm, I would hand them my firearm, because I understand officer safety. And that's the one thing that I do understand is if that's a request, I'll let them hold my firearm while we talk, if that's what they want. But the initial interaction between me and the law enforcement officer, if it has anything to do with seizing firearms, that's a whole different story, because that's what we're trying to do, is make a clear distinction. If they're in the process of addressing somebody that's in violation of a federal law or a Wyoming state law, they can assist, as long as the primary purpose of their interaction is not the seizure of firearms, munition, or accessories. So I hope that's my interpretation of it, Mr. Chairman.
Any other questions?
Quick one.
Senator Ide.
Yeah, thank you, Mr. Chairman. Representative Worf. Federal laws on gun laws, where is the enumerated power in the Constitution for them to make those? Thank you.
Mr. Chairman, Senator Ide, therein lies the problem. There's some people that believe they have a different interpretation of what the Second Amendment says, what it means. I think it's written in simple terms that anybody should be able to understand what the Constitution says. I think it's been confused. It's been used for, to me, I would say, nefarious purposes. Nobody wants to see the bad guys having firearms, but nobody wants to see the good guys being disarmed. And really one of the biggest concerns that I have friends that are in law enforcement, and I've been told, well, we'd never agree to that. But to me, this allows protection for those officers should that ever arise. If their policy is to do that, this law would allow them not to have that policy. And it would stop them from ever being tasked with seizing firearms, munitions, or accessories. And so to me, in answer to your question, I think the Second Amendment's really clear, and I don't think there is any standing for them to come take any firearm or munitions or accessories that we legally have obtained.
Thank you.
Thank you.
Thank you, Representative Worf.
Thank you,
I
Mr.
think
Chairman.
we'll open this up to public comment.
Mr. Chairman.
Go ahead.
Thank you. My name is Alan Thompson. I'm the Executive Director of WASCOP, Wyoming Association of Sheriffs and Chiefs of Police. And I would just like to recognize the intention of the good bringers of the bill in both sides of the bodies and the stated intent as explained earlier, we understand completely. And I would like to point out that, there was a conversation about this being a bill that helps protect law enforcement in Wyoming from being ordered by federal agencies to do certain things. And I would say that protection already exists. Back in the 1990s, there was a major crime bill, gun bill, passed nationwide that initially required local law enforcement to do the background investigations pursuant to the purchase of firearms. Local law enforcement from across the United States fought back, sued the federal government, and won. In the Prins v. U.S. decision, there's not a mechanism for the federal government to order local law enforcement to do enforcement type things, especially of federal law. Those background checks were not passed as state law, they were passed as federal law. And Mr. Chairman, I would just like to draw you to the amendments that we provided prior to this. It's a one-page document that starts with HB 0130 proposed amendments on the top of it. These amendments are the same amendments that we have proposed in both houses that these companion bills have been heard in before. This has been sent to the Senate bringer of the bill, and it was, like I said, provided to the previous committee on this House bill version. There's slight changes in various versions of these because the Senate file and the House bill do not have the same pages and line numbers. This is the engrossed. This adjustment you'll see in front of you might differ from what we have submitted to those other committees because we're talking about an engrossed bill now that has been amended. So those lines and page numbers have changed. But between last year and this year, our concern with this bill is that it doesn't exactly do what the intention is, and it could put law enforcement in a position to be risk mitigators. And we are probably the riskiest government entity when it comes to lawsuits and liability and responsibilities to the community that we serve. And thusly are sued often for those allegations or violations. And the question has been stated over and over again about how this affects ICE and how there are absolute carve-outs in this bill for immigration enforcement. However, if you look at the entirety of subsection D, which I think it would start on, well, I have it engrossed here.
Page 5.
Page 5, line 19, the entirety of subsection D tries to get at that prohibition of preventing local law enforcement from engaging in gun-related task forces with the federal government. However, we have many leaders across the state of Wyoming that have agreements with ICE. They have agreements with other federal entities to enter into task force work. Most commonly, we refer to them as 287G. So if you look at the language in there, it says on line 22, page 5, who previously acted as an official, agent, employee, or deputy of the United States government. If any person has done that, every single deputy under a 287G will meet that definition. So as time goes by, 10 years down the road, 20 years down the road, rookie officers come in, they get trained, they go into this 287G program, they get promoted to sergeant, they come out of it, they spend the rest of their career. That person will always fit that definition, as will anybody else that goes through that 287G training, in addition to any of the other task forces. So pretty soon a chief or a sheriff has 20 officers and 18 of them meet that definition. And that definition brings increased liability because if they are alleged to have violated any component of this, there appears to be litigation for the act of it itself, for any officer doing it, and litigation from any interested party because they met the definition of the task force agent, former employee, or so forth. So as you look on the budget, we understand that, you know, the gist of this bill and the existing state law in Wyoming, and we absolutely want to follow it, and we've supported the existing law in Wyoming. And tightening this up, we're all about that, but we can't put officers and agencies into untenable situations where there's vague law, and solely about firearms is one of the big components of that vagueness, because lots of cases start one way and the only charge is a firearm charge. And not always do Wyoming state statutes align with. I think we'll hear some testimony today about how that impacts straw purchases and what's really happened. Straw purchases in Wyoming aren't somebody typically buying a gun for somebody next door neighbor or whatever. We're hearing evidence that they're buying them for cartels and things like that. That's solely a firearms investigation when you're talking about straw purchases. And Mr. Chairman, I don't want to belabor those points, but our amendments are on there with a slight explanation down at the bottom of it. I want to repeat that this does mirror a lot of the budgets or the amendments that we brought last year and in the other parties this year, and the other committees this year, and I'd be happy to answer any questions if you have any.
Questions? Senator Doc Smith.
Mr. Chairman, Mr. Thompson, confirming specifically what are your amendments? We're looking at the same thing.
So the piece of paper is almost a full page, and it just says House Bill 130 proposed amendments.
Okay,
on the
just
top
wanted to
of
make
it,
sure
in
we had
bold
the
and
same thing.
underlined.
Okay, thank you. Chairman, follow up.
Follow up.
Mr. Thompson, with these inserted, do you find some level of comfort?
Go ahead.
Mr. Chairman, I think we find a lot more comfort in that. However, we're looking at a 9-page bill here that drastically changes existing. We've done our best to go through this in the time frame that we've had to do this. We have talked about this a lot. So I can say that as of today, we would feel really good about that, but it's not a guarantee that we didn't miss some sort of loophole.
Thank you, Mr. Chairman. Thank you, sir.
Could you give me an example of a situation where there was a charge that when it all came down to it, ended up just as a gun charge?
So you'll hear some testimony in a minute on that. But Mr. Chairman, the hypothetical that we've talked to with some of our prosecutors would be you have probable cause to get a search warrant for drug-related crime. And oftentimes drug-related crimes involve the moving of those products and nervous people that move them just because they saw a black car drive by their house. So by the time you get the search warrant and you get back to the house, you get in there and there's absolutely no evidence of drugs. You've got the probable cause to get it. A judge signed off on it. You got a warrant. And then you come into that and you have someone that is now a felon in possession. Let's say those would be violations of state law. So let's say that this is part of a task force operation and then your teammates on that task force take it as a federal prosecution. I think that that opens liability to that officer on that team for the only charge in that would be a gun charge because there was no drugs found in there, even though the probable cause existed. That's solely about a firearm. It didn't start that way, Mr. Chairman.
Guess I'm having difficulty wrapping my brain around this. If they have the gun there and it's illegal, doesn't the officer, isn't he protected?
Mr. Chairman, I think we'll hear some other testimony from specific experiences that others have. A lot of times, one case leads into another case. So this drug investigation is over, or this homicide investigation is over. Now we look into the purchase and possession of the firearm to begin with. And those I think are solely about firearms. The definition of solely about firearms is going to be litigated in court for years to come. And I don't think this gives us enough protection to feel safe. And chiefs and sheriffs may just say, we're not doing that out of risk for both criminal and civil penalties. We just simply won't do that unless there's a Wyoming statute with a short, the Wyoming statute for felon in possession of a firearm is limited to dangerous felons. And then there's the misdemeanor component that catches the rest of them. So those are substantially less penalties than what we see with the federal government prosecution of firearms laws.
Any other questions? Go ahead, sir.
Thank you, Mr. Chairman, members of the committee. Get the readers on, excuse me. My name is Travis Koltiska and I serve as the Chief of Police of the Sheridan Police Department. Part of my message today, I've delivered a similar one in the committee before the House earlier, but it's here to discuss the real life operational impact if House bill as written would go into law. February 13th of this year marked the 2-year anniversary of a tragedy that deeply affected my department and our community. Sergeant Nevada Paul Krinke was murdered in the line of duty by a prohibited person, someone legally barred from possessing firearms under both federal law and prior Wyoming felony convictions for violent crimes. Following the tragedy, the Wyoming Division of Criminal Investigation led an extensive investigation alongside federal partners, including the FBI and the Bureau of Alcohol, Tobacco, and Firearms and Explosives. A key focus was determining how a prohibited individual obtained multiple firearms, including the weapon used to kill Sergeant Krinke. This type of investigation requires resources, legal authority, and interstate coordination that local law enforcement simply cannot accomplish alone. Cooperation with our federal partners is essential. Through that joint effort, investigators determined that the firearm used in Sergeant Krinke's murder had been knowingly provided by the suspect's mother. She was later prosecuted in federal court, convicted, and is now serving time in federal prison. Under the current version of the bill, that individual would have been considered a law-abiding citizen at the time she provided the weapon. More importantly, this bill may have prevented Wyoming law enforcement from providing any material assistance to federal investigators, including the sharing of evidence, information, and the side-by-side work that was conducted in this case. In practical terms, that means the person who armed Sergeant Krinke's killer may never have been held accountable. The loss in Nevada devastated our department, our community, and our state. It made a wife a widow, left a young daughter without her father and took a son from his mother. Holding accountable that person who placed that weapon in the killer's hands was essential to justice and to healing. I want to be very clear. In my 31 years in law enforcement, I have always been a strong supporter of the Second Amendment and the rights of law-abiding citizens. That commitment has not changed and is shared across Wyoming law enforcement. But protecting those rights must go hand in hand with ensuring that individuals who have lost their right through violent criminal conduct cannot access firearms, and that requires the ability to work with our federal partners. House Bill 130 as written would significantly restrict the ability and create real-world consequences for public safety and officer safety. Though I've been accused of politicizing this strategy by certain members of this legislative body, nothing could be further from the truth. This is solely about the need for cooperative law enforcement and the safety of the communities we all serve. For those reasons, I respectfully urge you to carefully consider the operational impacts of this legislation. Thank you for your time, and I'd be happy to answer any questions.
Questions? Well, thank you for your testimony.
Good afternoon, Mr. Chair and committee members. My name is Carl Germain. I serve as the Lieutenant Colonel for the Wyoming Highway Patrol. I'm here today to testify to the effect House Bill 130 will have on statewide law enforcement operations. While I strongly support protecting constitutional rights, this bill's broad prohibitions on cooperation with federal authorities will severely undermine law enforcement's ability to combat serious crimes in Wyoming. Federal data shows 45 to 50 Wyoming residents are prosecuted annually for federal gun crimes, often involving violent offenders, straw purchasers, or cartel-linked trafficking. These cases frequently stem from local, state referrals and task force work. Without cooperation, many won't be prosecuted at the state level due to jurisdictional limits. Some examples include combined drug-gun cases, which are common in narcotic prosecutions where the gun charge sticks, but the drug threshold doesn't meet the prosecution level. Violent crimes in Indian country, sexual offenses with ancillary weapons violations, transnational crimes investigated by the FBI, fugitive task force cases with U.S. Marshals, ICE cases on illegal immigrants possessing firearms, often tied to cartel trafficking from Wyoming purchases. I've heard a lot of testimony and comments about the ICE cases, and it's true that the majority of ICE cases, when that person is apprehended, just get deported. But we are seeing an uptick in Wyoming of gun crimes that would be charged federally. About 47% of federal case referrals come from task force officers and state and local law enforcement. Yet this doesn't capture additional work by state local officers providing testimony for support. For state agencies such as the Wyoming Highway Patrol and the Division of Criminal Investigation, this would drastically reduce partnerships with federal agencies, leaving sex trafficking, narcotics, and violent crime investigations unprosecuted or under-prosecuted. The bill prohibits using state funds personnel for any federal firearm enforcement cooperation with severe penalties, including agency fines, which creates a chilling effect. I fully support the WASCOP proposed amendments, which add necessary exceptions and clarifications to preserve critical joint operations without undermining Second Amendment rights. Thank you for your time, Mr. Chairman, and I'm happy to stand for any questions.
Any questions? Well, thank you for your testimony. Yes, sir.
Chairman, Senators, I'm Sheriff Aaron Applehance from Albany County, and I'm here also speaking on behalf of WASCOP. Just to kind of reiterate what my colleagues have said, that we have some serious reservations of this bill. I believe all of the senators received a letter from WASCOP a week and a half ago, letting you know that we weren't in favor of this bill as currently drafted on there. And what has been testified as what would be a gun mill to protect Second Amendment rights as written, it really comes across more as an anti-law enforcement bill. A lot of my colleagues from around the state, all 23 sheriffs, are opposed to this bill, as well as a number of chiefs from around the state. And as evidenced by a lot of my colleagues that are sitting behind me, taking a look at how this committee is going to go today as well. WASCOP has provided you guys with a number of amendments to address all of the issues that we have with this bill, that we could at least somewhat move forward and continue to do the job that we all swore oaths to do, and to protect our communities here. So in there, you'll see language in there to provide clarification that we won't enforce unconstitutional firearms laws. As written right now, the word unconstitutional isn't in there. Actually, the same language that is in there right now without our amendments is the same bill that was provided to the state of Missouri in 2023. That same bill was overturned by the Eighth Circuit Court of Appeals. If this bill continues to go forward as written, I think the only difference between the Missouri bill and the bill that we have here is that it's going to be overturned for constitutionality reasons in the 10th Circuit Court of Appeal, which is where we currently reside. So, like I said, there is a number of amendments. These amendments have been brought up over the past 4 years, and again, in another House committee earlier this week. Unfortunately, none of them have been adopted. And that's really one of the things that we wanted to testify to you today, is that all of us here are in favor of the Second Amendment. All of us here are in favor of protecting those rights of our citizens while providing public safety for the communities and the counties that we represent. Adopting those amendments that are in there really gives us the tool to do so. Passing the bill as is essentially removes the tools for us to do so. We don't think that you guys are trying to pass a bill that decreases public safety. But in terms of passing the bill as written as is, that would be exactly what you guys are doing. And we're asking you, please don't do that. Don't handcuff us. Let us do our job. So, like I said, if you want to go through line by line on all of those amendments, like it says, it changes the language in there to where, like I said, it mirrors some of the bills that we already have, or some of the laws that we already have on the books, allows us to go out there and still work with our federal partners, the task force. A lot of us are in jurisdictions where we don't always have all of the resources available for us to fully investigate or prosecute the crimes that we come across. Everybody is a partner here in the state of Wyoming. You guys know that this is a very large state with very long sidewalks. We're all part of one community, and we all help each other when needed. Like I said, passing this bill as is would remove those tools. So we're asking you really to do two things today. That's the testimony. Either vote to not pass the bill as is written, or adopt all of the amendments that we present to you today, so that we could move forward with a bill that allows us to continue to provide the public safety in which we provide. I stand for questions.
Questions?
Mr. Chairman.
Senator Dockstetter.
Sir, thank you. I have in my notes here, all 23 sheriffs oppose this bill. So I need some clarification in your last statement. If we have this amendment in there, then, and I don't know, maybe you or anyone here could comment for the sheriffs. If we move this amendment into the bill, then the 23 sheriffs are agreeable. And Mr. Chairman, I'm opening that to you or anyone at the table.
Go ahead.
Yes, thank you for your question, Senator. Yes, we're going to be much more amenable to it. The list of amendments that we put in there, I know are lengthy, but they're there for a very specific reason to basically do three major things. Allow us legally to continue the job that we are doing. Two, remove that liability that already exists to do the job that we're already doing. That liability is already there and can be addressed through other laws that we have here in the state. It doesn't necessarily need to be added into this bill here. And three, the amendments that we've added on there actually speaks to the true intent of this bill. The intent of this bill is, in the event of an unconstitutional law, executive order, rule, mandate that comes from the federal government, then essentially they want a trigger law to be able to protect the citizens of Wyoming, to where local law enforcement doesn't have to follow that federal rule. An amendment has in that list, I believe it's the last one, has been entered into that and been written out so that the language of this bill will then meet its intent. In its current state, it does not.
Thank you, Mr. Chairman. Mr. Chairman, follow-up.
Follow-up.
Sir, your 3 points are a good summary. Could we also hear from either verifying those 3 points from our other 3 witnesses?
You can nod your head.
Mr. Chairman, Senator, the Wyoming Highway Patrol supports those amendments.
Thank you.
Yeah, Mr. Chairman, I can't always speak on everyone at a time, but based on all the information that I've had leading up to this point, I feel confident that our members across the board, chiefs and sheriffs, would support this bill with those amendments.
Thank you.
Mr. Chairman, I would concur with my colleagues at the table and both behind me.
Thank you, Mr. Chairman.
Senator Ide.
Yeah, thank you, Mr. Chairman. I think the bringer of the bill may correct me, or there may be another amendment to maybe help with your concerns on this outside of this amendment here. I don't know personally if I'm ready to go through this amendment. I already see something in here, page 9, line 3, where, and I'm not just picking on this bill, I do it on a lot of legislation where it says under state law and you want to add or federal law. And for the same reasons, a lot of times those are unconstitutional laws, and I always just hate eroding our state sovereignty with adding that in there, including the money aspect of eroding our state sovereignty. So anyway, just a comment. Thank you, Mr. Chairman.
Mr. Chairman.
Senator Case.
At the proper time under your discretion, I would hope that they would go through the amendment, kind of the line by line. And because Senator Ide just mentioned part of it that he disagrees with. I hope, I'm not trying to hijack the committee, but at some point we could go through that line by line.
Anybody else? Well, thank you, gentlemen. Do we have any other testimony?
Good afternoon, Mr. Chairman. Art Washut, House District 36. I guess one area that I haven't heard discussed yet that I think is important involves domestic violence. We don't currently have state statutes pertaining to individuals who are under protection orders, as I understand it, with domestic violence laws. And there is federal law in that area, but we just haven't needed to address it in state statute because federal law had domestic violence covered. So one of my big worries, among others with this bill, is the impact on domestic violence and our ability for our Wyoming peace officers to intervene in those cases where federal law might preempt a convicted offender from possessing a firearm, but no comparable state law applies. And will our Wyoming peace officers feel empowered to protect our victims when the only thing keeping that offender with his firearm is the federal law? The only thing that keeps them from having that law is the federal law. So just a concern. We recently saw a case, right, in a completely different subject area, where what we as legislators thought a law meant years ago was later ruled not to mean that. And so I'm have a heightened concern this year that when we have laws that are somewhat ambiguous, I realize it doesn't matter what I think the law means. It doesn't matter what you all think the law means. That somebody else is going to make that determination down the road. And this opens up for lots of litigation where any, plaintiff's attorney who thinks that the law might fit is going to be filing this litigation against our peace officers. So I'm very concerned about the legislation, and I have not seen the amendment sheet that you've all been provided. But if anyone's under the impression that the only thing that's going to keep our Wyoming peace officers from joining an unconstitutional mass effort by the federal government to invade our firearms rights is the potential of a massive civil cause of action against our peace officers, I think that's a false premise. Our peace officers took the same oath that all of our veterans have taken to support and defend that Constitution. And I am very confident that our peace officers are not going to fall into lockstep and violate constitutional rights. I just don't think that's going to happen. So if anyone's under the impression that we need this law, otherwise our Wyoming peace officers are going to be campaigning with their federal counterparts to, violate our Second Amendment rights, I just think that's a false premise. Thank you.
Senator Dockstetter.
Thank you, Mr. Chairman. Representative, I was tracking the digest and the votes, so I take it your concern in your initial vote as this legislation was moving through the process, you didn't have this amendment to deal with, correct? Or anything close to it?
No, sir, I've not seen that before.
Thank you, Mr. Chairman.
Mr. Chairman, I wonder if we could get the representative a copy of the amendment so he could kind of look at it as well. Is there an extra copy somewhere? And does the sponsor have a copy of the amendment? The sponsor doesn't have a copy either.
Why didn't they get that?
Mr. Chairman, we'll get a copy of this.
Okay, great.
Thank you. I have a quick question about something you said earlier. So in domestic violence cases, we only prosecute people under federal law. We don't have state law against that?
Mr. Chairman, that's not what I said. What I said is that when it comes to people who are convicted of domestic violence, who are then in possession of a firearm, that is a federal offense. And it creates a threat potentially to the victims of domestic violence if they continue to possess that firearm. So we don't have state law that says that a person convicted of domestic violence cannot possess a firearm. There is a federal law that does that. And so we've never taken the opportunity to debate whether we should have a similar law because the federal law covers that.
Okay, thank you.
Chairman.
Senator Dockstetter.
Mr. Chairman, I thought as we have further testimony, if we could have our representative look over that amendment sheet, and if you'd like to come back up based on your approval to comment later while we move through any further testimony.
Sounds good.
Thank you, Mr. Chairman and Senator Dockstetter. Yeah, I don't want to say that I haven't seen it. We've seen this. This was presented the House committee. A lot of the problems that I have, like, for example, on the top one, it says page 3, line 23, reinsert unconstitutional. And then follow up with that, page 4, line 1, it says after government add as determined by the Supreme Court of the United States. The problem with this is who determines constitutionality? If an illegal order is sent down by the federal government, if we believe it's illegal, the only way we can get it determined to be unconstitutional is through legal efforts. And if the Supreme Court is saying that that's a constitutional law, I have a big problem with it, because I do not think that the government has the ability to seize our firearms, our ammunition, or accessories. And that's one of my biggest concerns. But I will tell you, we've looked at all this. We have adopted a couple amendments. We adopted some of the amendments last year when we passed Senate File 196, and we did adopt a suggested amendment. Let's see. I believe it's on the page that I sent you. There's one where it talked about if somebody had been in the military, and I don't see it right offhand, but we did adopt that, or we would ask you to adopt that, because the intent isn't to stop the good guys from helping with law enforcement. It really is just to stop law enforcement from violating our Second Amendment rights. And, when you put in unconstitutional, that to me means it's got to go through the legal process to be determined unconstitutional. And, if the Supreme Court issues a ruling that it is legal for them to seize our firearms, I have a problem with that. There's a legal process to fight that. That's what we're all engaged in today. But the problem is, once your guns are seized, it's like a black hole. We know, I think it was Katrina, when it come through and hit, there were a lot of firearms seized. Nobody knows where a lot of them ended up. When it came time to give them back to the people, there was no accountability where those firearms ended up. So, there's problems with this. I can see why they would like that, but it does change it, and it makes it to where the citizens would have to wait until it's gone through the court process, but their firearms have already been removed. And that's the thing that is the most concerning, is if you're disarmed, I think that's a bad thing to let that happen. Now, the one thing that I will say is, there's testimony that said, that if they're in the course of doing an investigation, like a drug investigation, and they stumble upon a firearm, that this guy's a convicted felon, that's the gun's not the issue. The issue is that you got a convicted felon in possession of a firearm. This doesn't prohibit that. What it says is the initial contact can't be, we're knocking on your door to seize your firearm or any of your ammunition or your accessories. That's what this is saying. It's not saying in the course of your actions and your duty that if you stumble across something, and in addition to the crime that led that law enforcement entity to interact with that citizen, if they're in violation of a law that was justified for them to initiate the contact, the gun's irrelevant. That's a second part. And even if that's the only thing that can be charged, I think that having the evidence that showed what the purpose was when they first made that contact, I think that's what insulates them from all these concerns, allegations that they have. I don't believe that they're real, but I know that these amendments have been proposed. I know sometimes when you put forward things and it doesn't go your way, sometimes you feel like nobody's listening to you. But I do believe we've looked at all this. We've talked with them. We've met with Alan a little bit, Mr. Thompson. And, you know, we just don't see that those amendments add to it. I do think you're in possession of a proposed amendment that I would put forward. And what this will do is we're trying to get Senate File 101 and House Bill 130 to mirror each other. Even though the amendments were the same, but the way that they were added to the document made it to where they're different documents. And all we're trying to do is make them mirror each other. So when Senate File 101 comes up, we'll be making a similar proposed amendment that'll make them both in lockstep. And that's the amendment that we got forward from the Sheriff's Department. And I believe it was already incorporated in Senate File 130. Now I'll look for that where it is. Yeah, if you look at engrossed copy of House Bill 130, on page 8, line 18 through 21, that was a proposed amendment that we did get from Wascop, and we agreed. We thought that it added to the bill. It didn't detract from it. So that is an amendment that we adopted on the House side, just so the committee is aware. We tried to work with them. We just didn't agree with the amendments that they would like to put into the bill.
Mr. Chairman. Go ahead, Senator Dockstader.
Mr. Chairman, Representative, it's getting confusing now, mirroring this, mirroring that. Let me come back to just a basic concept. Would you be absolutely opposed to this sweeping amendment inserted into this bill? Could we find common ground there?
Mr. Chairman, no, we cannot. And, you know, this was asked in that House Appropriations Committee. And the answer was that even if every one of these was adopted, they wouldn't be happy with the bill. And I think that's the bottom line. They're never going to be happy with this bill. They want it just to go away. But that's what concerns me. I do honestly believe that our law enforcement people are not here to violate our constitutional rights. But I can tell you that we've seen this happen in other countries. And I just think this is added protection for us. It doesn't limit what they can do. And I think it makes it clear that we don't want our law enforcement guys. I mean, think about your friends that are in any type of law enforcement. Do you think they want to get an order to go seize firearms from people in this state? I mean, how would it be if that ever were to happen? And I know everybody's told me I'll never do it. But when your boss tells you to do something, most people are going to do what they're told to do. And so that's all I can say about that, Mr. Chairman, because I just don't think anything would make them happy. And I think the things that they're proposing do alter significantly the bill. And like I said, my biggest concern is the constitutionality of it, because that requires legal action to go through the court, through the legal system, and have somebody determine that law is unconstitutional, or that act is unconstitutional. But if your firearm's already been seized, what are you going to do?
Okay, thank you. I think we're going to move on to the online testimony.
Yeah, thank you, Mr. Chair.
Mr. Chairman, we have Aaron Dorr online.
Bring him in.
Am I there, Mr. Chairman?
Good afternoon. Welcome to Revenue.
Thank you, sir. I'll be brief. You guys have a big day already. I'll go over the bill briefly for you, what the bill does do. But I want to spend most of my time, Mr. Chairman, Aaron Dorr, on behalf of the members of Wyoming gun owners, talking about what this bill does not do. A lot of sensational claims about what HB 130 would do. I'm going to kind of break that down. Briefly, what it does, it adds civil penalties into existing law. We already have SEPA on the books with a criminal penalty provision. This puts a civil component in there. That's on page 4 and on to page 5. Secondly, it says on page 3, the law enforcement cannot bypass SEPA by being attached to a federal gun task force with the federal government. Current law only precludes Wyoming cops from doing this if the money originates within Wyoming. This language on page 3, line 19 says, wherever the money comes from, Wyoming cops may not be used to enforce federal gun control laws. We add in peace officers in the bill as defined in 7-2-101. That's on page 4, line 9. That's a cleanup to the existing law. And we clarify that a concern that we have is that if we have it where law enforcement can leave their native agency and go through whether it's an MOU or some other agreement to a federal tasking for a purpose of circumventing SEPA and then coming back to their native agency, that's a workaround to SEPA we're trying to preclude. And so on page 5, line 19 through page 6, line 5, that is prohibited from occurring. So that's briefly, Mr. Chairman, what the bill would actually do. More importantly, here's what this bill does not do. On page 7, line 14 and 15, and on page 4, line 12 through 15, it makes it clear nothing in this bill prevents Wyoming from receiving federal assistance to aid in the enforcement of the laws of Wyoming. Any and all federal assistance can still be attained by Wyoming from the federal government. Money, personnel, databases, helicopters, equipment. Any and all help can be received by Wyoming to enforce the laws of Wyoming. Number 2, Mr. Chairman, this does not allow any individual law enforcement officer from being or to be civilly sued. This comes up an awful lot. If you look at page 8, line 14 and 15, it is very clearly prohibited. Only the agency or subdivision who employs the officer may be held liable for a violation of SEPA. So no individual cops can be civilly sued under this section. We've heard a lot about when Wyoming cops can seize firearms if SEPA becomes law. If you look, Mr. Chairman, on page 8, line 10 through 12, nothing in this bill prohibits Wyoming law enforcement from seizing firearms as part of a criminal investigation into a violation of Wyoming law. So if any Wyoming law is alleged to be violated, firearms can be confiscated incident to that investigation. That's again on page 8, lines 10 through 12. Want to clarify again, this does not, Mr. Chairman, stop all joint interagency federal task force work. The only task force that is precluded by this is on page 4, lines 4 through 5, and it only blocks these task forces who are solely created for the purpose of enforcing federal gun laws regarding firearms, ammunition, and accessories. And that means that all other task forces are permissible. FBI, DEA, ICE, the tribal task forces, all of these can continue to move forward. If an department chooses on their own to withdraw from those, that is a choice they are making, but nothing in this bill at all would preclude the additional task forces I just laid out to you a moment ago. In fact, Mr. Chairman, this bill doesn't even stop Wyoming cops from aiding the federal government in the apprehension of criminals, even if firearms are involved, if the underlying criminal act involved a felony drug crime or a felony persons crime. Look on page 7, lines 7 through 12, that's spelled out very clearly. So anybody who's coming into Wyoming or anybody who is already in Wyoming, the feds call and they say, we have a pickup full of fentanyl coming up I-25. Can Wyoming cops detain that person? There's a gun in the car, but the issue here is felony narcotics. Absolutely. Persons crimes, if there was a bank robbery, a murder, a sexual assault, a kidnapping, all of these felony persons crimes could also still be investigated. They could detain somebody who's alleged to have committed that crime. It's all spelled out there on page 7, page 7, line 7 through 12. We've heard a lot about this applying to different types of criminals, Page 9, line 2 through 6, Mr. Chairman, makes it clear this does not apply to felons, foreign nationals, or even non-residents of Wyoming. This only applies to law-abiding citizens who live in the state of Wyoming. Lastly, Mr. Chairman, what it does not do, it does not prohibit the federal government from enforcing federal gun laws in the state of Wyoming. That would be a supremacy clause violation, or at least it could be considered that way. We are aware of that concern. And so nothing in HB 130 limits the federal government's power to enforce federal gun laws in Wyoming. It simply says that Wyoming cops will not be allowed to help them do that. This bill has passed the other chamber on a third read vote of 49-12, and it passed your chamber, Mr. Chairman, in a different format, Senate File 101, last week, 26-5. A couple final comments, Mr. Chairman. We heard about the horrific situation in Sheridan, where the officer was murdered, and how this bill could in some ways interfere with or impede that investigation and that prosecution. With respect, I would disagree with that. Again, all state laws can still be handled, can still be prosecuted. Wyoming has a statute that deals with conspiracy to aid or commit murder. It's 6-1-303. To my knowledge, that makes it a crime for a person to give a gun to somebody as part of an attempt to murder a law enforcement officer. In addition, murder is illegal, obviously, in Wyoming. And so Wyoming cops could use all tools, state and federal, to investigate a violation of Wyoming law, which would certainly be what the homicide was in Sheridan. So I don't believe that concern, as emotional as it is, sticks with what we see in the bill. We heard about 287G training and these federal agreements where anybody who goes through that would then be denied the option to be a law enforcement officer in Wyoming. That's not the case. If you look at the bill, I don't have that page number handy, Mr. Chairman, but it says only if they actually enforced federal gun control laws would there be an issue there. So any Wyoming cop could go through that program, could be dual certified. All those arrangements could take place as long as that officer does not enforce federal gun control laws. He would not be precluded from being hired as an officer in Wyoming later on. Mr. Chair, you asked a question about drug dealers and could we still get guns from drug dealers? I've addressed that, I think, on page 7, line 7-12. And to Senator Ide's question about federal money, again, this bill does not preclude the state of Wyoming from receiving federal funds to aid in the enforcement of state law. The lots of litigation assertion, Mr. Chairman, I can tell you that Missouri was mentioned. And when Missouri passed this law, it was in the books for several years. To my knowledge, there were only 3 lawsuits that were filed during that time. All of those suits went nowhere. They were spurious lawsuits. They did not get past the first hearing because SEPA in Missouri had the intended effect, and it stopped the assistance to federal law enforcement to aid in federal gun control. And it was a non-issue. There was almost no lawsuits, and there will not be many lawsuits in Wyoming. And lastly, when it comes to Wyoming or to Missouri, Mr. Chairman, we heard how this is similar to the Missouri law. It would not survive a court challenge. That is not the case. This bill was drafted in the wake of what happened in Missouri. It has major changes from the law that was enacted in Missouri, and those changes reflect what the courts said in the Eighth Circuit, the issues they had with the law that was in the books in that state. With that, sir, happy to answer any questions.
Questions?
Mr. Chairman,
Senator Dockstetter.
Mr. Dorr, you acknowledged that this bill has already passed as Senate File 101. Why do we need HB 130?
Well, I think it's important to, in these short, compressed budget sessions, have a variety of options. Of course, we ran out of time to deal with this last year when the governor issued a veto, and so we're trying to maintain maximum schedule flexibility here to make sure we can get this thing accomplished this year after what happened last year.
Any other questions? Well, thank you for testifying in front of the Revenue Committee.
Thank you, sir.
Can we bring in who's next?
Mr. Chairman, we have Mark Jones. He denied. Never mind. Those are all we have online for this bill.
Do we have anybody else in the audience? Please come on up.
Thank you, Mr. Chairman. My name is Clint Becker. I'm the sheriff of Converse County, Douglas, Wyoming area. Been a peace officer for 40 years this year. Wyoming peace officer. I guess I got a simple question. Who is this Mr. Dorn or whoever, and where is he residing from? Okay, well, I just heard a lot of discussion from him. I don't really know who he is, and why he's not here or whatever. I just was curious.
He is the director of WIGO. And I'm not sure where he lives.
He was here last week.
And he was here last week.
Okay, alrighty, but it concerns me that the 23 sheriffs and the other peace officers within our state that are leaders have given some clear direction to the committee, but that the people that are presenting this bill have a problem allowing our amendments to be installed in it, I guess. And that's what I'll say just from listening to this gentleman. I forgot his name, what he said just a minute ago. Thank you.
Questions? Thank you. I think we'll close public testimony. Committee, what's your pleasure?
Mr. Chairman, I'm not going to move the bill unless there's an agreement we have the amendments in. And then what I did here clearly is that we've already passed, and I'm cautious about naming other legislation, but we've already passed Senate File 101, which is this bill. And so I won't be part of moving this bill through.
I'll move the bill.
I'll second it.
Mr. Chairman, could we get a line by line on the amendment as proposed?
Yes. But we had to move the bill to do that.
Yeah, I understand. I'm not, and if you want a motion on the amendment, I will do so to have this discussion. But I'd kind of like to hear all the way through it first.
Please go ahead.
Thank you, Mr. Chairman. Alan Thompson with Glasscob. I did compile these amendments based on information, so I'd be happy to go line by line through the amendments on the form that you should have in front of you. The first one would be page 3, line 23. Existing law makes it clear and understandable for law enforcement that this goes at any unconstitutional act. That's existing language in statute. Unconstitutional, it's existing language in statute. This bill would strike that language from it and leave law enforcement to question any act, law, treaty, executive order, rule, or regulation of the United States government. Our contention is we already don't do that. And this replacing the word unconstitutional gives us clarity in understanding what we need to enforce and not enforce. Move on to page 4, line 1. It just clarification for that unconstitutionality. So it says regulation of the United States government. There's some stricken language in there, but this seeks to add as determined by the Supreme Court of the United States, which is the ultimate arbiter in determining constitutionality. In line 4, page 20. By deleting knowingly and inputting willfully, it would help with officers. It's a little protection for the officers, because it could be argued that they willfully did something, but their intention at the time was to maybe, you know, be enforcing something that they thought was a state law violation, and come to find out that, you know, it doesn't fit. It would open that door to civil liability or criminal prosecution for that officer. We've heard a lot of testimony about this lawsuit or this civil remedy will not affect the officer at all. But we haven't mentioned that there is a criminal component of this also. That officer that makes the seizure could be facing a misdemeanor crime. A misdemeanor crime upon conviction will almost always result in the decertification of that officer to be a peace officer in the state of Wyoming. Misdemeanors or felonies, those often result in the decertification of the officer. So adding that or changing the word knowingly to willfully provides some protections to the officer.
I want to ask a question on that. What's really the difference between knowingly or willfully?
It's my understanding in talking to counsel that there's a little bit higher burden of proof between knowingly and willfully, with willfully being a little bit higher burden of proof on the person bringing suit or prosecuting under this to show that there was an intentional and willful act to do this.
Thank you.
So I think we're at page 5, line 15. So this in the next line, look at removing the language at the end of line 15 and all the way through 16 and 17. So it would remove, in addition to sovereign immunity, in addition, comma, sovereign immunity should not be an affirmative defense in any action brought pursuant to this subsection. Our membership feel like that's an attack on qualified immunity, even though it's not referred to as qualified immunity. It's referred to as sovereign immunity against the agency and not the individual. If it's against the law, it's already, sovereign immunity already does not apply. So adding this language in there is unneeded and further limits any kind of defense that somebody could bring to this, whether it be the agency or the individual officer. Things like mistake of fact. Officers are often prosecuted for or disciplined for a mistake of fact as opposed to an intentional willful act. And by removing that language, it provides more protections for both the agency and the officer. Page 5, line 19 is really the crux of the concern of this bill. We've heard testimony earlier that you know, we can do things with ICE and we can do all these other things. The council that we talk to, it absolutely calls into question any time that you hire somebody or put somebody through a task force and they would meet this definition of, goes on to the next page, I think. Oh, it's the bottom. So line 22, previously acted as an official agent, employee, or deputy of the United States government, and who knowingly commits a violation of this. The rest of this bill already makes it a prohibition for any officer working for the agency to seize firearms in pursuance of federal enforcement of federal law. This, then, if you continue it on down to well, it has the enforces, attempts to enforce, and then gives material aid. When you read all of those sections, it's our contention that brings additional liability just by simply having officers on your agency that meet that definition, that otherwise wouldn't meet that definition, still would be subject to this law. So now you have the one case where an officer seizes a firearm, and let's say it ultimately is found to be a violation of this. And because they were a previous task force officer under 287G program, now you have the $50,000 lawsuit here and additional $50,000 lawsuits here. And as we get into the persons of interest under subsection F, an interested party, any interested party can bring this. So I'm kind of getting ahead of myself, but they all kind of go together there. So if we're looking at, we're at page 5, line 19. All the way through to subsection E. So that takes us through page 6, line 18. We delete that section. It takes that double civil liability that we would incur by having that language in there, and that risk that agencies would have in determining if they want to participate in ICE or other task force operations. I would say that it's already going to be against the law should this bill pass. Why would we need that additional penalty section just because the person formerly worked for the federal government? We move on to page 7, line 9. Just kind of a cleanup. I'm not sure what when means in that sentence, but reading the whole thing going up to line 7, the person provides material aid to federal prosecutors for felony violations involving controlled substance or violations against another person when such prosecution includes weapons. I think and such prosecution is what we're trying to accomplish there, includes weapons violations substantially similar to the laws of this state. Now remember, this is an exception section here, but that's just to us provides clarity. In page 7, line 10, making a separate sentence there. So after violations, you would have a period, and then deleting substantially similar to the laws of the state if such weapons violations are ancillary to such prosecution. This is going out the vagueness. What does ancillary mean? For an officer to understand the application of this, I mean, we're barely through the middle of this bill, and there are so many questions about vagueness here that how can we expect an officer fresh out of the academy, fresh out of FTO on their own to understand the breadth and scope of this when some people might not even understand what ancillary means. So we would just ask that language be stricken. It is clear what the goal of this legislation is, and that just causes more confusion. Page 7, lines 11 through 12. Continue that deletion of that sentence. Page 7, line 14. So it would add options underneath that, accepting federal assistance for the enforcement of laws of this state, and then go into line 7 or page 7, line 15. Yeah, I'm sorry, sir.
Yeah.
Center right.
Thank you, Mr. Chairman. I think on page 7, line 14, that should say line 15, actually.
And the next one should be 16.
Correct.
Oh,
Go ahead.
sorry, there is an error. Yes. Looking at the end of line 15 and adding a semicolon there and adding another subsection that adds responding to or conducting law enforcement activity in emergency situations as an exception. We talk about all these ways that, an officer, as long as they're not enforcing just a federal firearm law, but there are times, and it's more often than we'd like to admit, that somebody's screaming on the radio for emergency assistance. I would hate to put officers in a position to have to find out what the crux of the issue at hand was before asking for such assistance. So that would add responding to or conducting law enforcement activity in an emergency situation. Page 8, line 3. It's another instance of the knowingly and willfully, which we've explained earlier. Page 9, line 3. This is the question that I know the bringer of the bill has the concern with. It's the enforcement of federal law. But I think we heard other testimony from other members of the House body that there are holes in Wyoming law when it refers to firearms. And so when we're defining a law-abiding citizen, we get an NCIC return and a dispatcher says this person is a prohibited felon and, you know, later on get back to the station and read the criminal history, and that prohibited felony violation does not meet the grounds for a felon in possession of a firearm under Wyoming state law. So these are when officers are working the street, being able to work on what they know to be the law at the time and adding that word federal. So state or federal law. And then going on.
I have a quick question. And this is just for my clarification. Can you get a felony in Wyoming and still own a gun? And if so, can you give me an example of that?
So
Thank you.
Mr. Chairman, so there's things like restoration of rights that call all that into question, and whether the criminal history shows that accurate information at the time. So if somebody was convicted of a Wyoming felony and got their rights restored, and chose to exercise their Fifth Amendment and not talk to officers, and they run a criminal history on them, that criminal history may still show, especially if there's something from another state. We found various errors in between other states, Wyoming, and federal government and restoration of rights processes. There is a statute in Wyoming that says that it shall be a felony to possess a firearm if you have been previously convicted of a violent felony and not otherwise pardoned or have a restoration of rights. And then it goes on to make a misdemeanor violation for those other felonies. But there are certain misdemeanors and things that seem to be unclear and in conflict with federal law that could put an officer into a position looking at a criminal history and seeing that they're a prohibited person based on that criminal history, and not being able to ascertain that without reading 15 pages of it to see and maybe look at interviewing the subject and finding restoration of rights processes going on. All of these things call into question the vagueness of this bill and open up loopholes for lawsuits to be filed against the agency. And ultimately they may win, but we haven't even talked about the cost of litigation and defending cases like this as a component, and what that cost agencies and the state of Wyoming.
Real quick follow-up. Wouldn't that be a problem with or without this bill? If I had my gun rights restored and you didn't find that, you took my gun, wouldn't I be able to follow after you civilly or even criminally? Because it just wasn't updated in the database? Thank you.
Yeah, Mr. Chairman, I do think that is the case. And I think there are processes already in case law and statute to allow for redress of these grievances that we're talking about, which actually calls into the question the need for this bill in entirety. I would say that does exist. Errors do happen, and there's already recourse for people to address those.
Thank you.
Then I think the final thing that we have there is a continuation of that definition of law-abiding citizen. I could argue based on this definition of law-abiding citizen, when it means a person who is not otherwise precluded under state law from possessing a firearm, and shall not be construed to include any person who is not legally present in the United States or the state of Wyoming. So we have a person that's legally present in the state of Wyoming, legally possessing a firearm, and they just committed a first-degree homicide. They are not convicted of that crime. Under that definition, they are a law-abiding citizen. They could have committed that murder directly in front of the officer. And under that definition, they're still a law-abiding citizen because they have not been convicted of that crime. So adding the language on page 9, line 4, an insert in that sentence is otherwise not engaged in felonious activities, start a new sentence, and this term shall not be construed to include a person who is not legally present, and so on. It just adds that that kind of protection in there to let us investigate crimes.
Senator Case.
Thank you, Mr. Chairman. I understand what you're saying there. It sounds like you'd really got to catch them in the act. What if the activity happened the day before? And I mean, you see what I'm trying to say? This says they're engaging in it right now. And I think that's almost too restrictive.
Oh,
You see what I'm saying?
Yes, Mr. Chairman, I do believe that there might be better wording in there. Or has not otherwise engaged in felonious activities might be a better statement in there. But I do understand. Thank you.
Thank you.
And Mr. Chairman, there's a final thought on there that, we're trying to get at the intent of the bill. And a lot of this testimony that we've heard over the last several weeks looks at, should we get, there's statements that we've heard is that we have a friendly administration to the Second Amendment right now. And should we get to a point where that's not so much the same in the future? And looking back historically at some of the gun laws that have come out of the federal government, just considering language like this or other language that would put this into it like a trigger effect. As it stands now, I think our partnerships with the federal government are working really well. I still haven't heard of any examples of us intentionally or erroneously violating people's rights that get us into lawsuit trouble. There's already ability to make those lawsuits happen. But what we're trying to, and I think most of our members would agree, what does the future hold for us? And can we be prepared to combat very overzealous direction from a federal government trying to impart rules on local law enforcement in Wyoming? I stand by my first statement that there's already that protection in effect right now in Prince versus US, but we don't know what tomorrow holds. So maybe considering adding language to make this a trigger bill instead of something that affects us tomorrow based on good relationships we have, task force we have built, examples. I was just looking at the U.S. Attorney's website and looking at the cases that we've prosecuted just within the last year in partnerships with local entities. And I'm a firm believer that the federal government in Wyoming would not be prosecuting cases without the work of local law enforcement. And I think this is going to provide a chilling effect on that.
You made a statement earlier that has me a little bit perplexed. If I'm a police officer and I watch a guy pull a gun out and murder somebody right in front of me, you think this bill protects the person that shot somebody? That state law doesn't allow for that police officer to take the gun away and arrest him? That's just curious about that. Thank you.
Yes, Mr. Chairman, I do understand that other portions of this bill talk about laws can be investigated. However, when you're looking solely at that definition of law-abiding citizen on page 9, those are the types of things that people that are sitting in jail cells have lots of time to write out lawsuits with a pen and a paper and file them. And as I mentioned before, the vagueness and difficulty in connecting portions of this bill cause question and concern from law enforcement. And at successful lawsuits and career-changing decisions are a concern. We want to protect our staff and officers, but also trying to combat unnecessary legislation, or I wouldn't call it unnecessary, but I'm looking for the word, but people can file lawsuits on this just looking for the $50,000 payday. And then we have to fight each and every one of those, because a casual observer would look at this and say, they took my gun and I was a law-abiding citizen. I'm going to file my suit. It's just not clear. And we want to make sure that we have a solid definition of what law-abiding citizen is in there. And if that's taken separately from those other components, I think that we still have that opportunity for those lawsuits to be filed.
Thank you.
Thank you, Mr. Chairman.
I think we have another amendment we should hear also before we take action on either.
Sure, Mr. Chairman. I would offer a version of this at the appropriate time, but you go ahead, do whatever. You want to do the other amendment too?
Senator Ide.
Yeah, thank you, Mr. Chairman. Yeah, on these amendments, just a quick comment. I mean, this one obviously has a few problems with it already. I don't think I have enough time to really digest all of these amendments and make a good decision on them. So I'd have to be a no from the start anyway, just to maybe move it up to the body to discuss and we have more time to deal with it. But that's just my initial knee-jerk thoughts. Thank you, Mr. Chairman.
Good knee jerk.
Representative Wharf.
Thank you, Mr. Chairman. Yeah, the page that I sent out to you, these are the suggested changes to House Bill 130. And like I said, most of this is editorial because you'll see it says page 6, line 3, delete for each such or for such employee employed. Then you see that page 6, line 6, so it's three lines down, for each such employee employed. It's the same thing. It's just making it in the right place. Like I said, we had similar amendments on all these bills. You'll see page 6, line 7, renumber I to A, page 6, line 14, renumber double I to B. The biggest one is this one. Is page 6, line 19, insert. And the interested party may bring civil action to enforce the provisions of this subsection. A court of competent jurisdiction may order injunctive or other equitable relief, recovery of damages, or other legal remedies permitted by law, and payment of reasonable attorney fees. Sovereign immunity shall not be an affirmative defense in any action brought under this subsection. Then it goes back, page 7, line 17, delete an interested party. And it goes down page 7, line 22, insert the after attorney fee, the following sovereign immunity shall not be an affirmative defense. And like I said, that's just to bring them both in line. I will be proposing amendments to Senate to the other bill. I'll just say, I don't know if I'm not supposed to mention the other bill, but there is a proposed standing committee amendment that will be introduced tomorrow, and it will kind of mirror this because the bills were supposed to be mirror bills. That was what we did, and I wanted it to be clear. I believe the reason why we were trying to make sure that these were mirrored bills, we're really just trying to get Senate File 196 back up. It was passed by both chambers last year. Unfortunately, we went home and 14 days later it was vetoed. So we're just trying to get them both there. And we want to make sure that it's the same because I want to be able to stand up in my chamber and say that it's the same bill as we had presented as Senate File 196 last year.
Do we have anyone else online?
Mr. Chairman, if I may, I know a question was asked about Mr. Dorr, and I think he would like to have the opportunity to answer that question. If you think that's appropriate, I would suggest allowing him to answer to the question that was asked directly about him and what he does and where he lives and all that. If you so desire, I think he's still there.
Mr. Chairman, we do have both Aaron Dorr and Mark Jones has requested again to try and be invited.
Okay, let's bring in Aaron Dorr because he can certainly answer personal questions about himself better than I can. Go ahead, Mr. Dorr. I think you're muted.
Mr. Dorr, we cannot hear you in the committee room.
Can he hear us? He can.
Yeah, he did a thumbs up.
Maybe we could go to the other witness while he tries to work that
Yeah,
out.
I think so.
Yeah, let's do that.
Mr. Chairman, it has again said he has declined the invitation.
Okay. Well, we could let Mr. Dorr keep trying to work on that technical problem and just go ahead and work the bill if that's all right.
Yeah, let's bring him back up, see if he's got it figured out.
If not, he can get his kid or something to help with that. I know how that goes.
Mr. Chairman, he is still on as a panelist.
Nope. So, Mr. Chairman, we have a motion on the bill. Can I move a modified version of the amendment from our friends in, there's no blue out there anymore. There's black and gray and olive and, but I would offer the amendment, Mr. Chairman, with some modifications. And perhaps Mr. Thompson will have heartburn with that, but I don't know. But I'm not going to offer all the amendment, but I would offer the part, page 3, line 23. That's a yes. I will not offer page 4, line 1, the next line, and page 4, line 20. So the next 3 lines of text I will not offer. I offer page 5, lines 15, delete, all the way down through the word situations, which is above the line, page 8, line 3. I offer all that along with line 1. Page 8, line 3, delete knowingly and replace with willfully. I will not offer that. That is not part of the amendment. So put a no there. I will offer the rest of the amendment down to page 9, line 18, which has to do with the effective date, and I will not offer the balance. So kind of looks like yes to line 1, no to 2, 3, 4, yes to page 5, line 15, all the way down to the word situations, no to page 8, line 3, yes to page 9, all the way down to the rest of the amendment, except for I will not offer page 9, line 18 to the end. That's what I offer.
Making a motion.
If I can get a second.
Second.
Do we want to take these one at a time or all together?
I would hope all together, just in the interest of time. But I did not offer the part about the Supreme Court having to make a determination. I did not offer the willfully part, and that occurs in 2 places. And I didn't offer the very end, which also talks about Supreme Court making an action. But the rest I offer.
Okay, it's been moved by Senator Case, seconded by Senator Dockstetter. Discussion.
Mr. Chairman, I think this will go a long ways. It doesn't solve all the problems that our friends have. It'll go a long ways and accommodate most of what they want.
Senator Hyde.
Yeah, Mr. Chairman, I'll be a no. I don't know exactly what we're doing here, and I think that one, if I understand you right, you were a yes on page 9, line 3.
It's actually, that is included.
Yes, okay.
And I'd be happy to divide that out separately. So if we could make a division and decide that one separately. And Mr. Chairman, I did make one mistake. Page 9, line 4. We changed that language while Mr. Thompson was at the table, where it says is otherwise. We changed the is to or has not otherwise. And I would offer that as part of the amendment. And with your permission, I would divide out the federal thing totally separate. Let's just talk about that separately. Friendly the second.
That is divisible. So we'll vote on the first part of the amendment, which is everything minus page 9, line 3.
Everything I offered minus page 9, line 3, correct?
Call the roll. Well, no,
It could be a voice.
we can do a voice vote. You're right. All those in favor of Senator Case's amendment, say aye.
Aye.
Opposed?
No,
No. That amendment has passed.
And then, Mr. Chairman, Senator, I cut the issue about federal. If we could just discuss that separately. It's still offered, but as a separate division. Page 9, line 3, after state and seat, insert or federal. And he might have a point.
Any discussion?
so, Mr. Chairman. So an aye and an nay on this particular one, if you're voting yes, you're for inserting that into it, and a nay would be against inserting that.
Correct.
Okay.
Yeah, and Mr. Chairman, I think there was some discussion about firearms law that we'd be enforcing, even though it's not specifically written in Wyoming law, but it would be under federal statute. I have a little trouble with that myself, but I'll just leave it at that.
I think in general, if we include federal law, we kind of don't need the bill at all, and we're just going to follow the feds.
Fair enough, for someone's interpretation of the feds, I think that's really what, or some, for example, someone's interpretation of immigration law, or.
Did I oversimplify this?
Yeah, so I'm happy to discuss that separately. I'm okay with whatever the committee does.
Mr. Chairman, could we have a clarification, a little more clarification on what we're gonna do?
So, Mr. Chairman, the only thing left in the amendment I proposed is page 9, line 3, after state insert or federal. And I'm becoming pretty, Senator, I raised a good point. Without objection, I would even withdraw that.
Any objections?
Okay,
Okay.
saved you a minute there.
Well, we'll move on to the bill.
What about Mr. Wharf's?
Yeah.
I don't really want to do his amendment. Just joking. Don't.
I think Representative Wharf said he was going to bring it as a committee of the whole amendment.
Whatever your pleasure. That might be good.
Yeah, let's do that.
But before we call the roll on the bill, Mr. Chairman, if I could just say, I don't like these mirror bills. I think it's bad policy and it ties up so much time. Every side goes and has to chew over the same ground. And I do not like this strategy of, well, let's introduce it on both sides. I don't get it. It wastes our time. It forestalls other things.
Any other discussion?
Mr. Chairman,
Senator Dockstader.
my notes for our WISCOM representatives, I'm not sure where they stand with these changes, but I think we're still there. With this amendment, they say, number one, it keeps us legal, removes liability. Number two, number three, speaks to the intent of the bill. And then one other point. I heard in testimony, bill has already passed as Senate File 101. So we already have this legislation.
Yeah, I think we should be careful, Mr. Chairman, about saying that our friends in law enforcement support the bill, because I did change their amendment. So perhaps they could say whether I'm sure that I didn't offer all of their amendment, only parts. They probably have to think about it.
Okay. Let's move on to discussion on the bill. Any more? Call the roll.
Mr. Chairman, this is a roll call vote for House Bill 130 engrossed as amended. Senator Case,
Aye.
Senator Dockstader.
Aye.
Senator Ide,
Aye.
Senator Pappas,
No.
Chairman McEwen.
Aye.
Mr. Chairman, you have 4 ayes, 1 no.
I will take it. That bill is passed. It'll head upstairs. Let's reschedule 147. And we'll move into
Friday?
the confirmation. Yeah, Friday. Confirmation hearing.
There is someone from the governor's office. Welcome.
We're gonna get started on this next bill, you said.
We're not. We're gonna hold it over till Friday.
I'm free.
Okay, the purpose of this hearing is on the issue of the confirmation of Wyoming Senate of Brett Fanning to the position of Director of Department of Revenue, which he has been nominated for by the governor. Introduce members of the committee: Senator Case, Senator Dockstader, Senator Ide, Senator Pappas, and Senator McEwen. And I guess we'll give you the oath. Do you swear or affirm that the testimony you give before this committee will be the truth?
I do.
We will move on to your introductory statement.
Well, good afternoon, Mr. Chairman. My name is Jerry Henderson. I'm a policy advisor in Governor Gordon's office. And I appreciate the opportunity on behalf of the governor to introduce Mr. Fanning to you all, and also the opportunity in your partnership in this important process that we have in the state of Wyoming. And that's the Senate confirmation of the gubernatorial appointees. Without further ado, I'll move in because I'm really honored to introduce to you a gentleman who is a Cheyenne native, who represents or shows deep passion for our state, and also, as you all know him well, has extensive knowledge in our state's taxation system. Mr. Fanning has bachelor's degrees in business finance and business administration from the University of Northern Colorado, which we won't hold against him because he shortly came back to Wyoming to work in the Department of Audit, the Wyoming Department of Audit, and get his Master of Business Administration from the University of Wyoming. As I said, he joined the state in 2011 in the Department of Audit, and after 10 years of experience there, Mr. Fanning joined the Wyoming Department of Revenue as the excise tax administrator. In that role, he directed the statewide administration of numerous tax types, including sales and use tax, lodging tax, wind generation, nicotine products, and prepaid wireless. Throughout his time at the Department of Audit and the Department of Revenue, Mr. Fanning has demonstrated his ability to ensure the state's integrity and its transparency as it comes to taxation in the administration of tax policies set by you all in the legislature. Mr. Fanning is a dedicated public servant. He has a robust knowledge of the state's taxation system, and he is a key asset for the people of Wyoming. Following the retirement of the agency's former director, I think we all knew that we had big shoes to fill in the Department of Revenue, and the governor knew that as well. That being said, we're confident in his selection as the new director of revenue, which occurred around summer of last year. With that being said, Mr. Chairman, again, thank you for the opportunity to speak with you this morning. And I hope that you all will consider his confirmation favorably.
Any questions?
Quick question.
Let's hear from the man.
Good, good. Oh, yeah, go ahead.
Thank you, Mr. Chairman. Again, I appreciate the kind words from the governor's office and Mr. Henderson. Yes, please don't hold that against me as well. I was very fortunate coming out of high school that I was able to gain some academic and some athletic scholarships. And so after high school is where I decided to play baseball at the University of New Mexico. And so
I
played.
move to accept this nomination.
Thank you, Mr. Chairman. Played baseball there for 2.5 years, then transferred up to the University of Northern Colorado. And so finished my bachelor's degrees there, got an MBA. I had to get something from the University of Wyoming. And when I was making the decision on whether or not to come back to Wyoming, I was very fortunate. Had a lot of opportunities. I was involved in a lot of clubs outside of athletics at the University of Northern Colorado. And I was dead set on moving down to Colorado to value mutual funds. And I had a very good, my dad was a referee here in the state of Wyoming for over 30 years. Just got recognized in the Wyoming Hall of Fame as a referee. And he had a very good friend that said, I had a job opening. It's in the state of Wyoming. You want to come back home? I said, what do I have to do? And very good mentor of mine, really good friend. And he said, you're going to get to travel around, crunch numbers, and learn about all the different types of businesses in the state of Wyoming. That was my entry-level job at the Department of Audit, was I got paid to travel around the state, around the country, to learn about how businesses, how taxation works here in the state of Wyoming. Great experience. I was gone a lot. I was tremendously gone, but it enabled me to learn about all the areas of the state. And so that was fantastic, giving me some of the experience, in addition to what I learned from former Director Noble, former Director Henson, and myself. It's been quite the ride, quite the journey. And so I'm honored to be here in front of you for Senate confirmation. So, and with that, Mr. Chairman, I would stand for any questions.
Senator Hyde.
Thank you, Mr. Chairman. I'll be brief. Excited to bring you on board. It's been fun working with you the last 4 years. I do have to ask you a tough question. It's been pressed to me a few times. So if you don't mind, and I don't understand it as well as I'm sure you will, but it has to do with oil and gas royalties. Like if you had $500,000, 12.5% royalty that goes to the federal government on federal lands. And I think industry feels like they're getting taxed more than they're supposed to on that. And I'll just keep it brief there and just see what your answer is on that. Thank you, Mr. Fanning, Director.
Mr. Chairman, Senator Hyde, yes, a tough one right off the bat. I am familiar with that conversation. And so we've got this, it's in our severance tax statutes where you've got federal ownership that owns certain parcels of the land here in Wyoming. Generally, those contracts are going to be at 12.5%, generally. And so what is happening is that over the years, the valuation methods used by the federal government have started to differ from the valuation methods that we actually have in statute right now. And so again, it's a conversation that we're having right now. We're continuing to have. We've been in consultation with the industry, with the governor's office as well, to try and see where there is some uniformity that we can come together, some collaboration that we can work on. But yes, there is conversation to be had on the federal mineral royalties, the 12.5%, and whether that's an exemption or deduction as it applies to Wyoming statute.
Thank you, Mr. Fanning, Director.
Yes, sir.
Senator Case.
Mr. Chairman, Mr. Fanning, would you talk about what you see as the greatest challenges facing Wyoming and the revenue front and the Department of Revenue's participation as we go forward? Like say the next 10 years, what's going to be the big things?
Mr. Chairman, Senator Case. Okay, vision of where taxation in Wyoming is going on. Was watching Director Henson's conversation and her Senate hearing that Senator Case you'd presided over. And it was amazing how at that specific time, the property tax conversation was not the main conversation that we're having right now. And that's just in 4 years. And so trying to envision the next 10 years going forward, couple thoughts come to mind immediately. The first one is, yes, there's going to be discussions on severance tax and oil and gas in the mineral industry here in Wyoming. You've all read and are party to some of those discussions that I am as well. There are going to be challenges on that front. We know that there are. From the property tax element, right? Is this kind of bubble subsiding a little bit? Maybe it is, maybe it isn't. But property tax, I've all told you that going back to 1935, the Emergency Sales Tax Act, property tax was a major discussion there as well. So property tax debates are not going away as well. Mr. Chairman, I've heard you talk about reform versus revision versus kind of temporary fixes, how all that comes together. The Department of Revenue is willing to partner and happily to partner with the legislature on how to make those ideas come together. Challenges, mineral industry, sales tax has become an important discussion, a really big discussion in the past few years as it relates to consumption taxes, property tax, should we implement it, should we get rid of it, all those discussions. But the mineral industry, right now we've got a favorable administration at higher levels. Hopefully that's the case, but maybe it's not always the case. But Mr. Chairman, Senator Case, happy to partner with anyone that we need to, because there will be revenue challenges going forward, and it's just how we address them as far as taxation or from an expenditure perspective.
Thanks. I'd go farther, but time.
Senator
Mr.
Dockstetter.
Chairman, the legislative body has been very creative in addressing property tax relief. Do you have concerns that may perhaps we have caused more confusion than helped?
Mr. Chairman, Senator Dockster, the simple answer to that is yes, there is confusion. That is the most straightforward answer. But truly, I do want to applaud the folks in the room, the folks behind me, my amazing staff, and our local county assessors, county treasurers. This has been a collaborative effort between all of those. And again, partnership with the Department of Revenue to do the best job that we could, given the statutes, to help our constituents understand what's been going on in the property tax realm. Yes, it was a lot of moving pieces, a lot of different exemptions. The Department of Revenue was tasked with making sure that gets on your notice of value, and then at the end of the day, your tax bill is correct. So a lot of educational aspect there, and we're not done. We certainly are. We know all of you that there's property tax bills being discussed as we talk right now. Those are ongoing. The confusion is out there. It is. We are trying to mitigate it. A lot of the bills that have come before you and this other body this session have been a lot of administrative items to maybe align dates to help, to maybe do some educational on the administration practices at the local county assessors level. All of those, a task with everyone to try and make sure that if a constituent is due an exemption or a reduction in their tax bill, that they understand that that's available to them, and the Department of Revenue is ready for that as well.
The good news is I need to sit down with you before the interim. I have a couple more reform ideas that might streamline and simplify everything.
Thank you, Mr. Chairman. Happy to sit down.
Thank you.
I would move that the committee forward the name of Brett Fanning for Department of Revenue to the entire Senate for confirmation.
Second.
It's been moved and seconded. Requires a roll call vote.
Senator Case,
Aye.
Senator Dockstetter,
Aye.
Senator Ide,
Aye.
Senator Pappas, Chairman McEwen.
Aye.
Mr. Chairman, you have 5 ayes.
Well, congratulations.
Thank you so much, sir.
So Squeaker brought his own peanut gallery. He needs a haircut. That's just a jealous saying, though. He does not. You do not. You do not. Thank you, Brett.
I do appreciate what you do.
Thanks to Governor's office. Tell us the excellent thing we
Mr. Chairman,
thank you.
Mr. Chairman, are we adjourned?
Yes.
We will adjourn this meeting.
Thank you, Mr. Chairman.
Thanks.